While it's generally a good practice to do so anyway, you should always think twice before you post. Insurance companies and their attorneys are keeping a close eye on your social media. Well, we want to welcome back Charleston attorney Gus Anastopoulo, who warns the most innocent and seemingly benign post could get you in trouble. Great to have you back.
Thank you, Layla.
I completely understand this because even just in everyday life, someone says they're having a super rough day, but then you see them, partying 2 hours later. It's incongruent with the message, right?
And you're absolutely right, Layla. And I think it's just human nature. We curate our best moments to share with the public online, right? You're not sharing moments of struggle, moments when you're sick. You're sharing when you're happy, you're strong, you're feeling brave. You share those best moments for the world to see.
And oversharing.
Oversharing sometimes, occasionally. And unfortunately, what we're seeing more and more of is those happy moments that we are sharing are often getting twisted and turned against you by the insurance companies.
Yeah, and that can happen just in general, too. I mean, people do it, so why not use it as a tactic? Is that considered an invasion of privacy, or is that fair game?
Unfortunately, it's fair game. I mean, if you're putting it out there, you should just assume that the insurance company is going to do it. These insurance companies have full departments of digital detectives that the second that you file your claim, they are crawling all your social media accounts, every post, every tweet, every story, check-in, and they're looking for moments to counter any sort of claims that you're making or call into question your credibility.
Are they looking at the start date of when the accident happened moving forward, or are they going back into your history at all?
They're going back into your history.
Really? So that can actually make an impact?
Absolutely, and certainly within limitation, right? For example, if a client's claiming that maybe they had a shoulder injury, but there's a picture of them in a cast 2 years before on that same shoulder. That's when it can become an issue. So certainly whatever you're putting out there, you want to assume that the insurance company has seen it or has access to it.
So that would be one example of misinterpretation. Is there something else that could be misinterpreted?
It happens a lot, right? The big thing is if you're just showing any sort of joy while you have a claim pending, then God forbid you smile in a picture, because you can't possibly be depressed or injured if you're out smiling in a picture. But that's ultimately what they're looking for.
And how do judges respond to this? Because let's say someone says, the accident, as a result of the accident, I've lost a huge chunk of my income, but then you're seen out having a beautiful 5-star dinner. Well, who's to say who paid for it, first of all? And do judges ever put their foot down and say, hold on, that doesn't necessarily work?
I've seen it go both ways, Layla,
really?
Because certainly there's an argument there that it goes to their credibility. Again, it doesn't always tell the full story, but it kind of goes back to, if it's out there, just assume it's coming in. And the best way that I explain to all my clients is, if you're not comfortable with it being on a courtroom projector, don't share it. If you must share smart or don't share at all.
Right. And do you think that it's a good idea for people to go back and maybe deactivate or delete posts?
Absolutely not. And ultimately, one, because the insurance company already has whatever you would go back and delete, and two, most importantly, that could be tampering with evidence. Don't want to do that. So whatever's out there, you got to leave it. Don't delete anything, because that's just going to hurt you even worse.
Wouldn't you have to have some sort of a court order that says, or a letter that has been sent to you that says you are not allowed to delete anything? Otherwise, you can?
Not necessarily,
okay.
And so that's one argument, but ultimately it's arguably evidence that's related to your damages, whatever you're sharing. And so if you're deleting evidence that could possibly prove or disprove the damages that you're claiming, then that's evidence. In South Carolina, you have a duty to preserve evidence as relative to the claim. So I don't want to say for certain, but I would say as a general principle that would be evidence that you would have a duty to preserve as you.
How would you safeguard your information? How would you go about safeguarding your social media presence?
Radio silence, plain and simple. As soon as you have an active claim, post nothing, alert your group, say, don't tag me anything, don't include me in any group pictures unless you ask me first. So first off, I would say radio silence. Don't delete anything. And people think, well, if I have my account private, you know, that's enough. But in the best analogy I can give for that is that, you know, that's essentially like locking your front door but leaving every window open. Because these insurance companies ultimately they create fake profiles. They may purchase your data through a broker, and ultimately they can just subpoena it. So you just assume that even if it's on a private profile, they can get it.
Lie low.
Lie low.
Lie low. All right. For anybody who wants more information on your law firm, where should they go?
They can find us online, guslawsc.com. Call us at the office 843-310-5555, or they can just stop by the office. We're at 5880 Rivers Avenue, North Charleston.
Gus Anastopoulo, thank you again for joining us.
Thanks, Layla.
Appreciate it. We're back in 2 minutes.